Am I on this now? I can't.
You are on. You are on, Dan. Welcome. Thank you for being here.
My thanks to all who've been doing this for so long. And I think that the issues have not been clear to journalists and to media in general for a long time. They thought it didn't apply to them somehow. And there have been questions raised about why really is he in the Ecuadorian Embassy? What is he really fleeing here? Is it Sweden? Will the U.S. really bring charges against him? Has there really been a sealed indictment against him, as his lawyers have believed or assumed for a long time? If so, what would the charges be? Would they really be charges that apply to us? All those issues have been settled now, as of now. And not entirely from his first charge that was raised against him, which journalists could feel had to do with the password issue, which doesn't apply to us so much so far. But with the 17 charges on the Espionage Act now that have been leveled, the stakes here in this challenge are very clear. For the first time, in a way, it's the first time in American history that any act, any legislation, or in particular the Espionage Act, has been used against a member of the media directly, and not just against a source. Mine having been the first prosecution of a source, and that was 50 years ago, actually, on June 13th, that I first copied the Pentagon Papers, gave them to a month later or so to Senator Fulbright, who didn't bring them out for fear that he would be, for various things that he didn't seem worth it to him, and Senator Mathias, various others had tried. Finally, the newspapers, we're in the 48th anniversary, essentially now, of their being published by the New York Times. So for all that time then, really from 48 years, I've been telling the press that the charges against me were based on the Espionage Act, could just as well be used against journalists as they were for the first time being used against a source. Now, at that time, the leading lawyer legal scholar of the law of information, Melville Nimmer, did an amicus brief for the ACLU in my case, which he later brought out in a law review, in which he said that the charges, the applications of the Espionage Act, and for that matter, the theft, which had never been used for copying information as a crime before. Now, in the digital era, to some extent it is. But at that time, simply copying it was not held as depriving an owner of the information of his property. And therefore, I wasn't guilty of that either. But anyway, he said the charges brought against me, there were 12 of them, 3 against Tony Russo, could not properly be applied to me, given the First Amendment. And if they were so applied, that law, such as the Espionage Act, would be unconstitutional. Now, legal opinion, the way the Act and the First Amendment has been protected in the courts since then is unfavorable. But I think as a defendant, and I'm not a lawyer, and obviously not an unbiased defendant here, but my case is over with, I think Melville Nimmer was certainly right, that applying those acts to either a source, or in this case, a journalist, does violate, contradict, really wipes out the First Amendment, certainly in terms of national security information, so-called. By the way, very little of it has to do with national security, in fact, or defense, in fact. But anyway, it has to do with spending, for example, $1 trillion at a time on the F-35 or on nuclear weapons and whatnot. And it's basically has to do with a long-term, massive annual subsidy to the aerospace industry, and to some extent, vehicle industry for tanks and whatever. Ever since, I think essentially the basis of the Cold War, and the reason we have a new Cold War against Russia and China, namely that ISIS and even Iran does not offer a rationale for spending $275 billion a year, and especially does not offer a rationale for nuclear submarines and for, they're trying to make those relevant, by the way, by making the warhead for the submarine small enough, this is an issue in Congress right now, small enough that it can be used against terrorists with a warhead that's only 5 times, or in some cases, 1/3 the explosive capability of the Hiroshima bomb. It's still, we're talking now about hundreds of tons to thousands of tons of explosive. And maybe by stretching, you can use that against ISIS. Not really. What you really need is an enemy like Russia or China with enough targets and enough area to justify, not justify, but give a rationale for thousands of warheads to be built and vehicles to be built by Lockheed, Boeing, Raytheon, Grumman, and so forth. But anyway, the law acts. The Espionage Act does not use the word classification because when it was written, there was no classification system back in 1917. It wasn't until the Second World War. So it talks about information relating to the national defense. Now, that's pretty broad. Used to say vague. Every issue, of course, of the New York Times and every page practically of almost every page of the congressional record will have information relating to the national defense. But that was modified, they thought, in a way to make it constitutional, narrow enough, by saying that it had some relation to the injury of the United States. Namely, and I'm quoting here now from 18 U.S.C. 793, paragraph E, the only law I can whip off like that because I was the one accused of it for the first time as a source of information. And the narrowness is that this information is information that could be used to the injury of the United States or to the advantage of any foreign nation. Now, give an example. Any criticism of the president or of our defense policy, such as I've just made, by the way, could be used, obviously, to the advantage of some foreign nation who wants to criticize the United States or say that the weapons we're poising against them are not really necessary to the defense of the United States. That would be to the disadvantage of the United States, that is the president or the DOD, and to the injury of the United States, to the advantage of a foreign country. It could be claimed. It's extremely broad. To make it possibly applicable, the courts have interpreted that as including any classified information. Now, of the billions of pages of classified information at any time, hardly any of it satisfies the actual definition of secret or top secret, which is would injure the United States. It's classified because it would be embarrassing. I'm talking about the vast majority of these pages would be embarrassing to some official or some administration, and they don't want it a matter of discussion or knowledge to the public that can change people through elections. They don't want it known to Congress or courts or whatever. But I want to emphasize, the reason I'm going into this is that the Assange case now, I think, should bring home to the press for the first time the paragraph E of that, which is, and whoever having unauthorized possession or access to or control any document, note, whatever, or information relating to the national defense, and as I say, that's interpreted as being anything classified, even confidential, which the possessor has reason to believe could be used to the injury of the United States or to the advantage, not what will be, probably will be, thinks will be, no, could be used, who willfully communicates, delivers something to any person not entitled to receive it, that's any person without a clearance to start with, or willfully retains the same and fails to deliver it to the officer or employee of the United States entitled to receive it, is guilty of a crime against the Espionage Act. Not guilty of spying, guilty, as I was charged, of a non-espionage charge under the so-called Espionage Act, which is 18. Now, if you were following what I said, and I may have to repeat it, I've described something that applies not just to every journalist, every secretary in the New York Times, let's say, or any other newspaper, editor, publisher, and person unauthorized to receive classified information who has access to, possession of, control, and so forth, information. Right? That's everybody in the media business. But notice something else. It's every member of the public. How would they get access to that? Well, how about reading a page of the New York Times that says, this is based on a classified document which has been made available to the New York Times or which has been seen by the New York Times. You see that every other day or every week, certainly. Now, the person reading that now has access to classified information. They've been told, if they believe the Times, the enemy of the people here, and the false news and so forth, but they don't know whether it's false or not. So they have access to it. If that person, well, first of all, they don't even have to communicate it to anybody. Having access to the information and not who willfully retains it, keeps the page in their hand, or transmits it to somebody. How about their spouse, or their child, or their parent, or whatever, or a friend? Hey, look at this, classified document here from the printed here in the New York Times. That fits the wording of the Espionage Act, absolutely. Well, people would say, oh, they're not going to prosecute a reader. That's true up to a point, but for 40 years they've been saying they won't apply that to a journalist. They won't apply that to a journalist, and they never had. So I say the wording is there. It's obviously unconstitutional, but don't worry about it because they're not going to use it. And indeed, president after president who hated journalists for some story or other has backed off from experimenting by using that wording, which clearly applies to the journalist as well as to the reader, from using it against the journalist because it would be too blatant a violation of the freedom of the press in the First Amendment. And they would lose the Espionage Act as a threat to hang over every member of the government, because everyone is told, as I was told dozens of times, signing agreements on information, there's a footnote or a page that's the, I understand that if I give this information, I will be subject to prosecution under 18 USC 793 D and E. And D, by the way, is for people with authorized possession, such as me. So I signed that many times, that I was subject. No one ever told me that no one ever had been prosecuted under this. And I assumed I was anybody who did that would be breaking some law, and here they were telling me what the law was. Actually, we don't have a law like that because we have a First Amendment. Nearly every other country, most other countries in the world do have laws, like the British Official Secrets Act, that criminalize any delivery of or possession, whatever, of classified information. We don't. So the experiment here was to use the Espionage Act as if it were an Official Secrets Act and as if there were no First Amendment. So what's changed here now? I think what's changed under Trump is not that he's more, hates the press more than Richard Nixon, by the way, who said, always, the press is the enemy. Remember that. They're our enemy. But he said it privately. He did say it on tape. He was taping himself, which he never expected to get public. But the difference between Nixon, who talked about Jews and blacks and everybody as racist as anybody since, including Trump, did it privately. And the difference with Trump is that he comes right out with it and says these things openly. But one other difference, why didn't he do this criminal act, this charge 2 years ago against Julian Assange? The charges are the same. They've had the information forever here. I think because of the two new justices he's put in the Supreme Court. It's the same reason that we're seeing charges brought now for, not charges, but new legislation on abortion all over the country now, in the belief that we can now get the Supreme Court to change the Constitution, basically. Overthrow Roe versus Wade in a first step. That's not even changing the Constitution, just overthrowing the Supreme Court judgment. I think they're now counting on the fact that with the new justices and the balance in the court, the new court won't notice that a prosecution of Julian Assange is unconstitutional. And he won't be the last. In fact, this indictment warns every member of the press that they can be indicted for dealing with, even retaining information that's been given to them by anybody, make them much more reluctant to handle that or do anything with it, even receive it. Remember, Chelsea Manning tried to get the New York Times and the Washington Post interested in her information, collateral murder and others, before she went to WikiLeaks. And they weren't interested. The same would apply to many other people. So what is at stake here is the First Amendment of the United States, of the Constitution, with its freedom of the press and other freedom of religion, freedom of speech, and definitely other things being directly assaulted here now in a way that ought to get the attention, I think, of the media and perhaps of Congress. And I'll just close here with this comment by saying, for 40 years, I've been saying that wording used against me, an experiment, which was dropped because of governmental crimes against me, domestic crimes. Everybody here gets a lot more concerned about domestic crimes than about invading a new country or attacking something that's warned us by the New York Times today, with Pompeo claiming, without presenting any evidence, that Iran is responsible for blowing up tankers in the Persian Gulf. That is a precursor to war. I would say that anybody in the government, in NSC, in CIA, in NSA, White House, who knows that there is counter evidence, by the way, about that within CIA or NSA, disagreement, conflict, or that plans exist for using such, quote, provocations to launch a war with Iran, which would be catastrophic, even though it wouldn't involve Iran's using nuclear weapons, but could very well lead to the Americans using nuclear weapons, as Vice President Cheney wanted to do. And we know that because of a leak to Cy Hirsch that Cheney had called for nuclear plans against Iran back in 2006, 13 years ago, and that there was pushback on that from the Joint Chiefs who didn't want to do it. And that, I think, that leak led Bush to overrule Cheney on that point. If there's information like that right now, people should consider putting that out. I say consider because the price of theirs may be what Julian Assange is facing, life in prison. And that's a very serious prospect, obviously. But averting a war with Iran, which we're being lied into, and we absolutely should be given to WikiLeaks, but preferably to the New York Times. Test them on that one, and the Washington Post, and Congress, and everybody else. Even though we now know from the examples of a dozen prosecutions and now Julian, that anybody associated with that leak could face life in prison, as Julian is faced with, as I was faced with, for that matter, as Chelsea Manning was faced with. So that's a heavy, heavy price. Could it be worth it? A war's worth of lives is at stake here. Catastrophic happening. Of course, I would say it should be leaked by someone. Of the hundreds, maybe 1,000 people who would have access to that information, will there be one who's willing to sacrifice their risk, high risk, not a certainty, of sacrificing their freedom? Well, I consider that I'd risked my body, like millions of other Americans in Vietnam, in a war that should not have been held, in an unjust war. It seemed to me, yes, it was worth risking life in prison to try to shorten that war. And I've never felt that was a mistaken decision on my part. And I would say right now that should be leaked right now, despite the example of Julian's prosecution charges here. And from the point of view of the media, what I've been saying, I keep saying for 50 years almost, those words are a landmine, a buried mine for you people directly, even if it hasn't gone off yet. Now it's going off right now. They are on warning right now. Whatever happens to Julian in the future, he then should be the subject of support of the First Amendment. I thank you all for having given that support so long and so freely, and it's got to be kept up and make the country aware of what is at stake. And I say freedom of the press and of speech has never been more important than on the eve of a catastrophic, unjust war against Iran right now.
I saw a statement online today that said, don't Iraq Iran. And I found that to be very powerful. They're saying, do not allow Iran to have done to it what was done to Iraq. Dan, we have a number of questions for you from viewers. One person has asked, do you still believe in the US justice system at all? And if so, why?
Interesting question. I was asked frequently in China when I went there in 1995, of all things, as for USIA, to talk about the independence of the judiciary. An interesting thing for them to send me on, because they thought, after all, I was an advertisement, and I am for the independence of the judiciary. I am free, despite having been charged with 115 years possible sentence, pretty comparable to Julian's 175 years, but it would come to the same thing in terms of our life imprisonment. So there I was. They were interested in advertising me to China as somebody who could show the justice of the system. And of course, I did say that's self-evident. Here I am. I wouldn't be free in most countries of the world, democratic or undemocratic. I did say at the same time, we had a situation where the law being used against me was unconstitutional. The mere fact that it was written down as a constitution was not a full protection here. The law was unconstitutional. The many acts, criminal acts, were taken against me to shut me up from further disclosures during that, including wiretapping, burglarizing my psychoanalyst office for information to blackmail me. This at the orders of the White House, tapping phones of my friends on whom I was overheard in various ways without a warrant, criminal acts, an attempt to kill me, actually, or incapacitate me totally on the steps of the Capitol on May 3rd, 1972. So I said, having this in your Constitution, which the Chinese, needless to say, did not have and do not have, and they put people in jail for against freedom of speech then and now for nothing more than breaking an embargo on a public speech and publishing it a day or two before it's published. That had happened just before I went to China. So I said, even if you did get it in the Constitution, that doesn't enact itself. It has to be, a lot of people have to take measures actively to protect it. And it is true that when those acts were leaked by various people and said under by John Dean under oath in his plea bargaining in general in Congress, taking on the president just as Julian Assange has taken on presidents, and that is a dangerous thing to do, whatever status you're in. Granted, then, that did have the astonishing effect of freeing me from those charges just before they went to the jury, despite the fact that the judge had been offered his lifetime's ambition to replace John Edgar Hoover, who had just died, as head of the FBI. That was his childhood ambition. And he didn't turn it down. He discussed it during my trial, but it was leaked by someone, I think almost surely by Deep Throat, who turned out to be Mark Felt, number 2 or 3 man in the FBI, who himself wanted to replace J. Edgar Hoover. So he leaked the fact that my judge had been offered that job. In other words, we have a situation here of a dynamic process where people who did tell the truth, like John Dean under oath, or Alex Butterfield, who revealed the fact that Nixon had taped himself, and Elliot Richardson, who refused to fire the special prosecutor, having been ordered to do that just as Trump was ordering people in his, other various people to fire the special prosecutor. Same situation. But it was leaked, it came out, and it did work. And moreover, Congress actually stopped the funding of the war at that point, which they tried to do on Yemen within the last month. And that was the second time after my case, the situation in 1973. That was the first time a legislature had voted to end funding of an ongoing war, so far as I know, anywhere in the world. And it waited until this month for a second time. And they actually voted it on Yemen. A pursuit of an unjust war by criminal means couldn't be more aggressive and criminal. And the president vetoed it at that point. So it's still going on, but it may still work. So in answer to your question, there is great injustice in our legal system, and far from it working just the way it's written down in the Constitution or in laws. But it can be made to work by people who do out of the ordinary effort and take risks themselves to take on the establishment. It can be made to work, not with any guarantee and at a risk. So there is my trust in the judicial system. I am the walking evidence, and others, there are too many others, who show that it can work. That's all we can say. And frankly, that's my optimism for the human species, and not just for that country, not just for this. When we look at climate and the nuclear arms race, my optimism consists of saying there is a chance we will escape the consequences of our past behavior, the CO2, the weapons that are on alert, ready to go and destroy most life on Earth. I actually see no clear way with a Republican Congress or with a Democratic Congress that these risks to our species, to our civilization, will be surmounted. I don't see how. It looks impossible. But impossible things can happen in human affairs, and they have. The Berlin Wall did come down. The Vietnam War was less easy to end than people thought. That did happen. Mandela became president of a country where no one thought it possible, in South Africa, which did not have our constitution, that system of apartheid would be overthrown without a violent revolution. But it did happen. And that is, our chance of surviving is no more than that of such a miracle in human affairs happening, but it's not less than that. And I have to go now, so thank you for the opportunity. And let's keep working to preserve the freedoms, the possibilities that does give us, preserve those possibilities. It's up to us to do that. Thank you.